Hey, this is Drew Page. Welcome to the Drew Page channel. In this video, I'm going to talk about the U.S. Supreme Court making a ruling on one of my favorite areas of law to practice, which is personal injury. If you find this video helpful, please subscribe to the channel, like the video, and hit the notification bell so you can keep up to date with all the videos that come out. And I'll try to get some more going here. Like I said, the last couple weeks have been crazy with me dealing with some PhD stuff and being away for a week. And I'm going to be out again another week at the end of June. So I'm going to try to pump out as much as I can so I can keep things going for you. If you have any suggestions for the channel, please feel free to share those in the comments below. And let's get started. So the U.S. Supreme Court normally doesn't deal with car accidents. They save that for us ambulance chasing lawyers, who, by the way, don't chase ambulances. But anyway, normally those kind of cases are heard in trial courts, and it's very, very rare that even a state Supreme Court will hear an issue on automobile accidents. I've argued once in front of the Virginia Supreme Court, the full panel, and I won that appeal. But that's all I've had as far as personal injury accidents go with car accidents. Now I've had another appeal case as Supreme Court that I've argued is still pending, so I can't really comment on that at this time. But at any rate, in this particular case, the U.S. Supreme Court has taken a look at an automobile accident case. And the reason is because it involves Medicaid. Now, what happened was a 13-year-old kid was walking off the school bus in Florida. And when the kid got off the step of the bus, a car impacted and hit the 13-year-old and caused some catastrophic injuries. The government provided Medicaid for the child to the tune of over $800,000, and the family got an attorney. I believe the child is in a persistent vegetative state, so unconscious, not moving, and is going to be needing care in the future. And Medicaid has agreed to continue with those expenses because the family signed an agreement stating that the state has the right for reimbursement for all medical expenses. Well, the lawyers filed suit for $20 million, and ultimately they settle the case for $800,000. And they allocate a certain amount, about $35,000 and some change, to be toward past Medicaid expenses. But they don't mention anything about future expenses in the settlement. And so they end up arguing with Florida and saying, hey, Florida has a Medicaid statute that allows a presumptive amount of 37.5% of recovery of the total settlement for medical reimbursement expenses. And they argue, the plaintiff's lawyers argued that they should only have gotten a $35,000 and some because there's no way to show that, what the value of the future medical expenses are. The state of Florida was saying, well, no, the presumptive amount is what it is, and it's on you to suggest that it's not. So they were arguing they should get $300,000 out of the $800,000 settlement, which obviously would not leave the child with much after the attorney's fees and that recoupment. So they file a claim seeking declaratory relief to have the Medicaid Act declared improper, and the state's scheme a violation of Medicaid, the Medicare Act. So they go through the different channels and ultimately ends up in the U.S. Supreme Court. And the key argument is whether the state of Florida has a right under the Medicare Act to be able to get reimbursement for future medical expenses that Medicare, Medicaid are covering. And the U.S. Supreme Court decides in favor of the state of Florida. They say that, there's nothing in the plain language of the statute that says that they should not be able to get reimbursement for future medical expenses if the Legislature had decided they wanted to limit it in that way, they would have put that in the statute, but since they didn't, and with Justice Thomas being a strict constructionist of the Constitution, he looks to the plain language and says, this is what it says. It doesn't limit it to future benefits and expenses. So therefore, Florida does have that right. And unless the plaintiff can rebut the amount for the future expenses by clear and convincing evidence, then the state of Florida is going to be able to recoup that $300,000 of the $800,000 settlement. My guess is, had the lawyers known that it was going to work out this way, they probably would not have settled for $800,000. Now they sued for $20 million, but just to give you a window into how this works, I mean, attorneys always sue for more than what they think the case is going to be worth. They do that for negotiation purposes, and plus, you can always, you can't ask at the jury trial for more than what you sued for in the prayer for relief, or what's called the ad damnum clause. So if you sue for $20 million, you can't get in front of a jury and ask for $25 million. So, but you can always ask for less. And the amount sued for generally in most states is not evidence. So the fact that you sued for $20 million, the fact that you asked for that amount in the complaint is not evidence and is not proper to be brought up to the jury. So if you sue for $20 million, you can say, well, this case is actually worth $10 million, so I'm asking the jury to give 10, but you can't go above. So that's why lawyers sue for more than what the case is worth. And I know that there's lots of clients who they see a number like 20 million and they think, oh, well, that means I'm going to get like 15. No, that's not how it works. What probably is the case is there's probably $1 million insurance policy limitation on this accident, and the fact that they discounted it, that $200,000, was essentially to avoid having to go to trial to get it done. And they assumed that they were going to get Medicaid to be able to reduce the lien, because most of the time Medicaid does reduce their lien substantially. But since Florida has a statutory system laid out already, they didn't feel they needed to do that. So they took the money away from this 13-year-old kid to reimburse the state. So anyway, it was kind of an interesting case. If you rely on government help in getting medical expenses, then you can expect the government to reach back into the settlement or the verdict and get their money back. I mean, that's how it works with the government. If you sign a lien to the hospital or to physicians saying that you're going to, they're going to put a lien on the full amount of your recovery, then you've got some thinking to do. So anyway, if you're ever in an accident and you're not sure what you need to sign and what you need to do, the best thing for you to do would be to contact a experienced personal injury lawyer right out the gate, even while you're laying in the hospital. I mean, I know that sounds crazy, but as long as you're conscious and able, if you're conscious enough to sign away your rights, you should be conscious enough to contact an attorney. And even if you're in another state and you've been in a car accident and you don't know who to call, send me a message or call my office. All my contact information is in the details. And if I can't help you, I can point you in the direction of somebody who can give you some help. So hope you found this video helpful. Please subscribe to the channel, like the video, and hit the notification bell. And until next time, stay tuned.